All right, guys. So today we're going to talk about the Michigan red flag laws that take effect February 13th, 2024, here in Michigan. Now, for many of you, like myself, this is a pretty alarming law. It's pretty concerning. Today, I don't want to focus on, the all of the gun stuff with it. Okay. I know there's a lot of people out there that are concerned about, law enforcement showing up to your door. I don't think that's going to be a thing, at least not from our local law enforcement. And so I really want to focus on some different things within the law, but I want to look at like the kind of behind the scenes type of thing, right? The psychology of it, our interaction in everyday life as human beings. And so in this discussion, I really want to see what your guys' opinion is as well. I don't want to give room for the negativity or the name calling and stuff. So as you comment, please be respectful of other people's opinions because we all have one, and it's not that they're right or they're wrong. They're just different, and they're a matter of opinion, right? And so try your best to be respectful of other people who maybe don't disagree with guns because I want to hear from those guys too. I've had a lot of these conversations already. I've been interviewed for things like this. And so I really just want to get a different take on it, if you will. First, let me just tell you guys, I'm not an attorney. I follow the laws because I have to. As far as when they change and stuff, and I do abide by the laws. And but I'm not an attorney. I can't give you legal advice or even explain this thing correctly in the legal sense. We do have a seminar coming up April 9th in Lansing. It's on our website. I'll give some information to that later on. And so I just want to just put that out there for a disclaimer, if you will, about not being an attorney. But I do want to break some of these laws down and talk about them because I think the scope of this thing is very concerning. And I only want to highlight a few things. We'll get into some more detail about these later on down the road. But I just want to talk about some things that uh, alarm me and as well as many other people. And then give like my perspective on what they actually do. So this red flag law was brought into legislation, passed, and it was to prevent gun crimes from happening. This is a gun control measure, so they say. All right. Well, let's look at this for a second. The first thing I want to highlight here is that you don't even have to own a firearm to be a respondent to a red flag law. And by respondent, I mean someone has filed a complaint against you. Okay. You are the problem. They filed the paperwork. You don't even have to be a gun owner. All right. This will prevent you from becoming a gun owner. And in a later video, we'll get into like how they do all that, get their stuff back and all that. But just for the simple concept and the basic format here that we're going to talk about, you don't even have to have a gun. You don't even have to be a gun owner. All right. The other thing that's alarming is the amount of people that can file this complaint. Okay. It's virtually anybody. It can be family, it can be friends, it could be spouses, it could be former spouses, it could be, people in past relationships, people at your place of employment. Um, I don't even know if they even necessarily have to know you, to be honest with you. They don't even. I know they don't have to live in the state of Michigan. Just the respondent, the person that the complaint is being filed against, has to live in the state of Michigan. The the petitioner does not have to live in the state of Michigan. It could be people in your household, which has its own sets of problems if you have roommates or relationship issues or whatever. But it can also be children. All right. There's a lot of people that this law applies to be a petitioner. But in all actuality, anybody and everybody could be a respondent. And so I just want to get that off the table. You don't have to own a firearm. All right. One of the largest concerns to me is right here in section 5 of this law. And I'm going to read it and then we will talk about it for a second. But I want to see if this makes sense to anybody in there or how anybody feels. and maybe see if you know of situations that this might apply realistically. Section 5. First, let me read Section 4 so we can nail out the firearm thing. An individual may file an action against in or under this section, regardless of whether the respondent owns or possesses a firearm. Okay, boom, done deal. 5. This is the alarming part. This is where it starts to get interesting. If the respondent is one of the following individuals, and if the petitioner knows the respondent is one of the following individuals, the petitioner shall state that in his complaint that A, the individual who is required to carry a concealed pistol as the condition of the individual's employment and is issued a license to carry a concealed pistol. B, a police officer licensed or certified under the Michigan Commission on Law Enforcement Standards Act. C, a sheriff. D, a deputy sheriff. E, a member of the Department of State Police. F, local corrections officers. G, a employee of the Department of Corrections. Those are two different things. I mean, they're the same, but they're two different ones. Right? Someone who is a local corrections officer is going to work inside of a facility, the penitentiary. A person who works for the Department of Corrections could be a state worker, like human resources or probation or parole officer or a social worker, something like that. And then we have G, an employee or H, a federal law enforcement officer who carries a pistol during the normal course of the officer's employment, or an officer of a federal bureau of prisons. For one, what's the deal with prisons? People in corrections that have these types of authority, whether they're local or federal. But I want to just talk about this for a second because this was really really alarming to me. And if you're law enforcement and you're hearing this, uh, let me just tell you, I don't agree with this. Maybe you do. Maybe you know of different situations or circumstances. I don't, and so I still don't agree with them. But I do value what you do for our communities. I value that you're willing to be underpaid for a very dangerous position. So I thank you for serving our community and our communities around Michigan. And I think you guys do a fantastic job, even though you're underpaid. And I gotta say, I believe this is a slap in the face to y'all if you're in law enforcement. But I just want to kind of talk about this as a main point to this conversation piece here. Is let's take law enforcement and put them in the spotlight for a second. Think about their level of training, for the most part, or in whole. Before these guys even get out on patrol, they got to go through an academy and do all this training and things like that, right? And so they're not just thrown out there just winging it, right? They go through some pretty extensive training, and then they're always continuing their training. So for those in law enforcement, these guys are even, and when I say law enforcement, the corrections officers as well. They go through de-escalation training. They go through, stuff with kinesthetics and micro expressions and, behavioral changes and all these different things, firearm stuff, hand-to-hand stuff. They go through a whole lot of training and they continue in that. So they understand the level of threat in their environments that are changing every day. Okay. And I think that that's a pretty big element to talk about because when we're talking about domestic violence and someone that shouldn't have a gun because of that type of history or that type of attitude, this is completely separate from law enforcement. I'm not saying that law enforcement, they don't have guys in their divisions or whatever, that this has never happened, but I'm saying for the most part in general, this is not how that works with them. Okay, most of these men and women are pretty honorable people, and they hold themselves to a higher standard. They respect other people not because you're respectable, but because they're respectable. Okay, I hope you caught that correctly. And it's not to say anything bad about other people. It's just that's the standard that they follow, right? And with their level of training, it's very hard to see how they could be targeted through this. But I'm assuming that this is why this law was created. And when you look at the characteristics and kind of the departments, most of these guys and girls that serve in these communities in these dangerous environments already have unity in their departments for the most part. And most of them also have pretty good bonds with each other. And so when you get people who do that with bonds and having unity, even within family, but we're talking specific to law enforcement, that develops a different type of atmosphere. So even if they have problems, they can already go to other people inside their community of law enforcement and share things to get things off their chest, to learn how to mitigate different things and how to be responsible with maybe issues that they might have. All right. And so I have to ask myself, why put that in this law? Why was it's almost to me, it seems like law enforcement is being targeted in this very moment. In fact, I think that as officers learn about this law, I think it does something to the morale, right? It brings it down. It certainly does not boost the morale because by the way it reads in the law, it's almost like there's reason to not have confidence in the people that we trust to serve our communities. So I got to be honest, I think it's bullcrap that this is even in the law. I think it's alarming and concerning at the same time. And I'm kind of curious, which is something I'm going to look into later on. We'll do several videos, I'm sure, on different problems and concerns and misunderstandings within the red flag laws here. But I'm also kind of curious to see if there's any other states that have red flag laws that have this same kind of thing put inside their laws directly towards law enforcement officials. And then I'm also curious to see is how many states that do have the same laws for police officers and sheriffs and corrections officers and all these things we lifted off or listed off. I would like to see how many of those police departments resigned because of it. Well, maybe not because of it, but how many of those police departments have resigned or struggled solely based on my opinion about this law? That would be interesting to know. Because if I was a law enforcement officer, I would resign solely off of that. Because now you're putting my family at danger, you're putting my employment at risk, you're putting my career at risk, and you're disrespecting who I am, who I stand for. And you're saying that I could be subject to these things, but you trust me with a gun. You trust me in a vehicle. You trust me to make the right decisions, but yet you put me under this. I think law enforcement already struggles to have the respect as authority figures in our society, anyways. I don't think they needed this. I think it's a big slap in the face. What's your opinion, though? Okay. As we read these laws, like what are some problems that you could see going on with these? I mean, in Department of Corrections, those guys see a lot. And I'm kind of curious too is how does this law pertain to inmates filing complaints against COs or parolees filing complaints against probation officers or parole officers? You know, the other thing that is kind of questionable, and I don't fully understand yet, and I can't wait for a law seminar because I am going to ask this question. It says in Section 7, in an action under this section, the address of the petitioner must not be disclosed. Must not be disclosed in any pleading or paper or otherwise. The clerk of the court shall maintain the petitioner's address as confidential in this court file. The clerk shall provide notice of the hearing to the petitioner, now this is important, using the confidential address for any motion filed by the respondent or any hearing otherwise scheduled by the court. Let's talk about this for a second. So, now your address is no big deal, and it's really not. Just because it's concealed by the court doesn't mean it's concealed from public documentation. Now, so that's what makes me wonder: is this address or this being confidential solely from law enforcement, or does this mean just in general? All right. Now we'll read a little bit later on, but I want to come back to where it talks about um, the clerk shall provide notice of the hearing to the petitioner using the confidential address for any motion filed by the respondent or any hearing otherwise scheduled by the court. All right. Now, I think the fact they're going to try to conceal the address, which in all actuality is not a big deal. If you deal with, open source intelligence, you know what I'm saying is true. I can get your address off anything. It's very easy to do, very easy. And and so if you can't get it through courts, you could definitely get it by other means pretty quickly. But what happens to the rest of their information, and why the confidentiality? And think about this for a second. Let's just say hypothetically, because I don't know yet. I don't have any understanding on this, like I said. Let's just say that this doesn't just pertain to law enforcement. Okay, because law enforcement, anybody can, file this petition, do all this, and they'll probably never know who it is, right? Because they can't just make an educated guess because of the amount of people they run into all the time. But let's just say just, in everyday poverty people or population people, um, it's going to be pretty easy to narrow down who these individuals were, mainly because we're creatures of habit and we tend to form our same things, and we can remember disputes that we have with people. And so, does this really protect the petitioner? No. In my opinion, it doesn't. Because if I had it out with my neighbor 3 years ago about a very sensitive matter and we're screaming across the driveway at each other, I'm still going to remember 3 or 4 years down the road that we had that argument. Okay. It's not going to matter. But we'll talk about the history of things in a little bit. So, to highlight another thing that was concerning to me in this matter was Section 7, subparagraph 1. The action under Section 5, the court shall issue an extreme protection order if the court determines by the preponderance of evidence that the respondent can reasonably be expected within the near future to intentionally or unintentionally cause serious physical injury to himself or herself or another individual by possessing a firearm, and has engaged in the acts or made significant threats that are substantially supportive of the expectation. Interesting. I'm pretty sure people don't intend to hurt people when they get into car accidents. Maybe I'm reading this wrong. I don't know, folks. And significance threats. What is that? What is that? Because I know in the use of stand your or the use of force and stand your ground laws, if someone makes a threat at me, say we're at a bar or something like that, and he's like, "Hey, I'm going to kick your ass," and that's the time to deal with that threat. The very next day, if you see him and he doesn't kick your ass, that threat is no longer a threat anymore, right? There's no sensation of the threat. And so the fact that someone can calm down and it's not classified as a threat anymore, but it stands with this. It says made significant threats that are substantial. So does that mean that the respondent at the time has to be specific to times, dates, places, things like that? I don't understand. Anyway, it says, in making the determination under this subsection, the court shall consider all of the following: a history, any history of use, attempted use, or threatened use of physical violence by the respondent against another individual or against the respondent, meaning himself, regardless of whether the violence or the threat of violence involved the firearm. Now, I don't know about you guys, but in my mind, this can go sideways very fast in multiple different directions. Okay. This can be statements that they've made and now they're asking for a history. So is it really an emergency? Where does the threat have the fine line? That's what I want to know. What are the loopholes? What are the fine lines of what constitutes as a threat? That's that's good information to have, right? The other uh, questionable part that's pretty concerning is here in subsection 2. The court in the action under section 5 may issue an extreme risk protection order without, hear me on that, without written or oral notice if the respondent, or to the respondent, if the court deems by clear and convincing evidence from the specific facts shown by the verified complainant, um, or complaint, a written motion or an affidavit that immediately and irreparably injury, loss, or damage will result from the delays required to uh, this notice, or that the notice will itself um, have an adverse action. So you don't even have the right to have written notice. You don't, this whole law actually does not give you any. This has clear and convincing evidence. That's different from the preponderance of evidence. Preponderance of evidence, I believe the standard is a 50% accuracy of the facts, which is BS anyway. Anybody can do that. And so the fact that you don't have any grounds to have a hearing before they issue an order. Now this is specific to them issuing an order immediately, okay? But regardless, you still don't have a trial. There's no hearing for you to rebuttal what your adversary is saying you are threatening over. All right, and so that is very alarming to me too. And so I think the general public, including myself, needs a better understanding of how this works. As far as the way that the law reads, because as the law stands, will it work? I don't think so. I don't think so. What I think this law will do, though, is I think it will cause crime to go up, and I think it will escalate situations uh, in the workplace, in your communities, and even in your own homes, whatever environment you might find yourself in. And here's why I say that. Is because if we really look at like the situations where red flag laws could be applied, right? We already have an interaction with these people. Whoever the petitioner might be or the respondent might be, there's already a relationship there. And so they're already going to know that you're filing this at some point in time. And typically when people get ratted on, it it makes the feelings even harder. You know what I mean? Like there's a lot more resentment and unforgiveness in that, which causes people to lash out as well. And so I don't think that this law will help with any type of violence whatsoever across the board. And if we look at someone who is harming themselves, most of the time that's a cry for help. But if they don't and they're looking to inflict harm, most of the time the action is just committed without any warning, right? and So I think it's kind of a slap in the face to all people across all boards, whether you agree with guns or not. And, I've never been to a community where snitches were welcome. And so I think by allowing these types of things to happen puts multiple people in jeopardy here. The other part of this law that is really strange and odd to me is I don't even think it was meant or drafted in a way that was intended to protect anybody from anything. In fact, the larger percentage of me has to believe that this law was created to target people. And no matter what you think about targeting, the fact of the matter is this is it's happening. It's continuing to happen. We've seen this from, groups. We've seen this from people who just don't agree with senators, and we've seen it with judges. We've seen this from the FBI. Okay, even they will target people. I'm not saying that judges target people, but they have been targeted. So I think all of the way that this is structured and worded, in my opinion, opens the door for surveillance and targeting. And that goes for many classifications of people. I think that it helps the criminal carry out acts in a more systematic manner. And so that's what I really think we will see with this law, just because of the way that we interact. And if we look at the way that people interact on a daily basis in the environments that we're in and how we utilize, communications and body language and things like that, you can't help yourself but to believe that this law doesn't target, or you would have to be um, beside yourself to believe that this law would work. And so I guess I'm looking for understanding on this, because to me it doesn't make any sense. There's no justifiable reasoning where we should be targeting our law enforcement or giving a huge ability without proper explanation on what classifies as a the means, I guess, or evidence to have someone be issued a extreme protection order, or extreme risk protection order, I should say. So we'll wait and see how this unfolds, and I'll definitely be asking these attorneys questions on April 9th here in Lansing. Um, I don't know, guys. What's your guys' opinion? I know we haven't went through the whole law. This was just some of the parts that I was concerned about. I've read this thing so many times. My brain probably hurts from it, but I'm just trying to understand everything behind it. Like, how does this help communities? Because like I said it earlier in the video, it doesn't help in any other states. It hasn't. In fact, that's why partially I agree with this will only increase crime, because in states that have red flag laws, there has been no decrease in crime. And so I really, in the next coming weeks and months, I really want to pay attention to this, but I want some more understanding as well. And so I told you I would talk about a law seminar that we have. I know there's been many, many people ask specifically about this law, and with great reasoning, they do that. We are going to have a law seminar on April 9th. It's in Lansing. It is from attorneys that are two-way vetted from right to bear. It's from 6 to 8, 8:30ish, and you can register for that if you're interested in attending this. You can register on the website kingsmenpsc.com. That's KINGSMEN. P is in Paul, Sam is in, or S is in Sam, and C is in Charlie.com. Or you can just simply get on the Kingsmen PSC Facebook page. It is on there as well. And again, Kingsmen PSC at Twitter. Okay. Please, guys, let me know what your take is on this. I'm really interested to hear your thoughts and your concerns, as I've heard from many already. Uh, we'll talk to you on the next one.